welcome to another lecture on the constitution of the legal system of East Africa. In this lecture, we are going to see on the development of the Constitution of the United Republic of Tanzania of 1977 as it has been amended from time to time. So let's see the history on how it came into place. This is simply the history on how the German came into our land, whereby we are going to see the legal system during the colonial period. We all know that we were once colonized by the German as well as the Britain. We are told that German occupation of Tanganyika as a colony began with the exploratory activity of the German explorer, Dr. Karl Peters, through which he managed to obtain a large tract of land from the local chiefs, of which he was claiming that he was given these lands as a gift. So, in 1984, Karl Peters formed a company while he was in Tanganyika land, whereby he transferred that piece of lands to that particular company, and the rights in the lands alienated to him under the grants. In 1986, he formed a commission known as the Elimination Commission, charged with the task of eliminating the sphere of influence by each European nation on the African continent. Germany was granted with the large areas of land including Tanganyika, Rwanda, and Burundi. This was in the year 1891, whereby the whole area was declared as German protectorate. Meanwhile, there was a transition period to British rule. This was seen at the break of the First World War in 1914, whereby it opened the door for the British rulers or British interventions in Tanganyika. So the British came to Tanganyika through the First World War, which was 1914. So while the war was in progress, Britain proclaimed the martial law. So we are all aware of the martial law, whereby over all those parts of the territory which have been conquered and occupied. So we can see Article 119 of the treaty, whereby Germany renounces all rights over her colonial possession in favor of the Allies. So this can be seen in the Article 119. It was then agreed by the Britain that it should administer German East Africa with the exception of Rwanda and Burundi. So Rwanda and Burundi came under the administration of Belgium. Tanganyika came under the administration of Britain. There comes the League of Nations, which was replaced by the United Nations. In 1946, Tanganyika ceased to be a mandate and became a trust territory under the new trusteeship system of the United Nations. So this was in 1946. Let's see the English legal system. We start by seeing the legislature. Remembering, we are tracing on the development of the Constitution of the United Republic of Tanzania of 1977, on how it came into its existence. It was mentioned in the Tanganyika Order in Council of 1920. The legislative function in Tanganyika vested with the government. So this was well stated in the Tanganyika Order in Council of 1920. We are told that the position changed. It changed in the year 1926 when the governor legislative powers were transferred to the Legislative Council. So the position of the power changes from 1920 to 1926, where legislative powers of the governor were transferred to Legislative Council. This Legislative Council was also established by the Tanganyika Order in Council. This Legislative Council composition commenced business in 1926 with the followings. We had the governor and the president, we had 13 official members, and not more than 10 unofficial members appointed by the governor. So this was simply the composition of the Legislative Council. We are told that the governor, apart from assenting to bill passed by the Legislative Council, also presided over the sitting of the Sejm. We are told the governor was sometimes acting as the speaker. Members of the Executive Council, for this case the cabinet, sat in the Legislative Council as official members. So this is simply the history of how the Constitution was formulated. The integral part of the Parliament enjoys 7 rights over the Parliament. This is according to Section 40. So when you go through Section 40, you will see what it says. This is also part of Section 40, where the Judicial Services Commission was composed of the Chief Justice as the chairman of the Public Services Commission, and 1 judge designated by the government. So this is simply the composition. We are told that the Tanganyika Constitution had one glaring omission, because most other African and non-African independence constitution had included the Bill of Rights. Remember, as I've said earlier, that we included the Bill of Rights simply as a preamble, but it was never taken as part of the Constitution. That being the case, it could not be enforced. All these are the important sections. One would wish to go through them. This is section 42, which says, if the Governor General removed the Prime Minister from the office anytime between the holding of a general election and the beginning of the first session of the National Assembly on the ground that given the new composition of the National Assembly. So this is the composition of the National Assembly as according to the law. The Prime Minister will not be able to command the support of the majority of the members of the National Assembly. Let's now see the transition to the interim constitution of 1965. We are told that in 1963, Zanzibar attained her independence. This is well known. The constitution titled the Constitution of the State of Zanzibar of 1963 was then at place. The constitutional government thus established, survived and functioned for about 1 month. On 12 January 1964, the government was overthrown in a blood revolution which brought the power the Afro-Shiraz Party under the late Abeid Aman Karume in alliance with Umapat led by the late Abdurrahman Mohammed Babu. So this is the history of the Zanzibar Constitution. The decree within that particular constitution, among other things, spelled the division of power in the new government. It declared the intention of codifying the constitutional decrees, which were the form of the basis of the new constitutional order. We are talking on the constitution of the interim constitution of Zanzibar. Let's see one of the examples of the section of the decree that described on how powers was to be exercised within the council. We are told that on the codification of constitutional decree, the revolutionary government had on mind several decrees which it had promulgated immediately after the revolution. These were other declarations of supreme authority in the People's Republic of Zanzibar, the legislative power law of 1964 and the cabinet decree of 1964. Let's see on the union between Tanganyika and the Republic of Zanzibar. This was constituted when Mwalimu Nyerere, the then president of Tanganyika, and Sheikh Abeid Aman Karume, the then president of Zanzibar, signed an agreement called the Articles of Union, uniting the two sovereign states in one sovereign republic. So this is how the Union of Tanzania, means Tanganyika and Zanzibar, came into place. We are told before the ratification was effected, Nyerere addressed the members of the National Assembly in the following words. I quote, "I have called you here today for one purpose, to ask you to ratify an agreement of the union between our republic and the Republic of Zanzibar. This parliament is the sovereign assembly of the people of Tanganyika." So this was according to Nyerere's words when he was addressing that particular issue when they were signing the agreement. This is a continuation. So we have Section 6 of the Union Act, which is one of the provisions with a very important historical importance for today's future, of which one would wish to go through it and see what it says. And you can also see Section 7 for further reference. There comes the Constitution of the United Republic of Tanzania of 1977 as amended from time to time. This is sometimes referred as a permanent constitution. Among the series of the 5 constitutions, we had the series of 5 constitutions which Tanzania has promulgated since independence in 1961. The constitution succeeded the interim constitution of 1967. We have seen the history of the coming of the interim constitution, the Zanzibar constitution in 1965, which was supposed to last for 1 year from the date of its enactment. Let's see on the enactment of the Constitution. The same committee was appointed at the Constitution Commission required by the Act of the Union on 25th March 1977. We have talked of the Act of the Union. I've referred some of the section one would wish to go through. So the commission was appointed based on the provisions of that particular act. On the same date, the President appointed the Constituent Assembly, whose membership was the same as the pre-existing Union National Assembly. Remember, we had talked of the National Assembly, Union National Assembly. The Commission had started working on the Constitution formally appointed at the Constitutional Commission. So this is simply, as I have said, this is simply the history of the development of the Constitution of the United Republic of Tanzania. So we see the discussion in the part whereby the National Executive Committee, in any case, the National Executive Committee of the party was not supposed to be the forerunner to consider the constitutional proposals. The Constitution, which was enacted in 1977, came into effect in 26 April 1977. For further detailed account of the passage of 19 Constitution, one would wish to go through Shipp's writings. He wrote on the issues of the development of the Constitution of the United Republic of Tanzania in 1990. Together, you can wish to see some writings wrote by Fimbo and Mvungi. Let's see the amendments of the Constitution since 1977. The first amendment, Constitution Amendment, was done in 1979 by Act number 14 of 1979. This was undertaken in order to establish the Court of Appeal of Tanzania. After the collapse of the East African Community, the Court of Appeal for East Africa, which used it to hear all appeals. So this was very, very important in order to establish the Court of Appeal of Tanzania. We had the second amendment. This was effected by the Second Constitutional Amendment Act of 1980. This amendment was undertaken to accommodate the changes brought by the passing of the Zanzibar Constitution in 1979. So every amendment was done to include a specific purpose. We also had the third amendment. This was affected by Act number 2 of 1980. Why this amendment? This was to provide for a new number of members of parliament representing electorate constituents in accordance with the increased number of constituencies. We also had the fourth amendment. The amendments was carried out by Act number 21 of 1982. This was to institute a new procedure for the appointment of regional commissioners. So you take note of that every amendment which was done was to include a specific mission. We also had the fifth amendment, whereby changes in the Constitution in order to make the newly introduced a workable document, the bill styled Basic Rights and Duties. We had the sixth amendment, which was carried out by the amended Act of 1990, Act number 14(1). The Act introduced a new structure of the Electoral Commission. We also had the seventh amendment, whereby This was introduced by the Act number 6 of 1990. Essentially, it was amended the procedures for elections of the head of the executive Zanzibar. We also had the 8th Amendment. With the 8th Amendment, it was abolished the single political party system initiated by the interim constitution of 1965 and replaced it with a multi-political system. So multi-party system came into existence with the 8th Amendment of the Tanganyika Constitution. We had the 9th Amendment. Remember, I've said earlier that we had several amendments, and each amendment with a specific mission. So, with the 9th Amendment, it introduced a new procedure for the Union President election and those of the revolutionary government of Zanzibar. 12th Amendments. This declares the Union President, Union Vice President, Prime Minister, and the Zanzibar President are the principal leaders of the country. The 13th Amendment, we had the White Paper movement. We all remember it. The Kisanga Commission was entrusted with the task to superintending the public deliberation and the collection of the views thereof. You may wish to go through the Kisanga report for further reference. In this lecture, we have gone through, we are going through the development of Constitution. We have seen the historical development of Constitution. We have seen the historical development of the Constitution of Zanzibar. We have seen the Union Constitution. We have seen how the United Republic of Tanzania Constitution of 1977 as amended, how it came into place. We have seen several amendments which were discussed with their missions. So I hope with this lecture you have gained and you are able now to answer some of the questions pertaining the development of the Constitution of the United Republic of Tanzania. Thank you so much for listening.